As we further review the Election Petition Tribunal verdict in Enugu State as passed by the three-member panel of the tribunal led by Justice Kudirat Murayo, which dismissed the petitions of the Labour Party and its candidate Chijioke Edoga, insisting that they could not prove their petitions. In dismissing the petitioner's petition, the tribunal declared that the National Youth Service Corps discharge certificate is not a qualification to contest a governorship election. Edoga is challenging the return of Mbah as duly elected governor of Enugu State on grounds of submitting a forged NYSC discharge certificate over voting, among others. We are now joined by Fred Nzeakor, a lawyer, who will be reacting to Nzeakor's interview yesterday on the show concerning the governorship election petition tribunal judgment in Enugu State. Good morning, Mr. Fred Nzeakor, and welcome to the show.
Thank you. Good morning. Good to be with you.
Thank you.
Good morning.
Thank you for joining us. We're moving from Ebonyi now to Enugu. Yesterday we started with Enugu. Yes. And Affirms was here. And he said their lordships erred in law. And he tried to defend his points. First, the NYSC certificate issue. And he quoted from pages 109 forward. But I reminded him about pages 49 to 53, where, all that argument by the second respondent, being Peter Mbah, the governor, was brought up. And the fact that, look, the issue of forgery was not established by that tribunal. Yes. And that in any case, there was a pending case in court. But he said, well, still their lordships missed the point. So one of the reasons you are here. And then there was also an issue about locus, about whether this was a pre-election matter, whether the candidate was qualified or not. Okay, so I'm sure you watched the conversation with Affirms yesterday. So do you share his views? Do you agree with him that the tribunal erred in law on the major grounds of the petition, all the three grounds, three major grounds?
Unfortunately, thank you, Dr. Abati. Unfortunately, I didn't watch Mr. Affirms' interview, but I will lay the facts bare as it is. Of course, in the course of doing that, all the issues that he may have canvassed will be torn to shreds, because in my opinion, and in the opinion of most discerning lawyers, the tribunal did substantial justice to the issue. Not only that there was justice, the justice was also was seen to have been manifestly done. Let's take the issues one after the other. There were three main grounds of the petition. One was issue of qualification of Dr. Peter Mbah. Section 177 of the Constitution is very clear on what qualifies a candidate to run for the office of a governor. And of course, my good friend must have highlighted it. If he didn't, they include one, citizenship. You must be a citizen of Nigeria. You must be a member of a political party and must be sponsored by that political party. And you must also be at least a certain age. It used to be 35 years, but now 30 years by the new amendment. And Section 182 also talks about you must not be an undischarged bankrupt, in which case one should not be found guilty of dishonesty, at least within the 10-year bracket, because even that one has expiring date. So if you look at all those issues, and then one should also have attained at least a minimum of school certificate or its equivalent. So if you look at all those qualifying conditions and parameters, Dr. Peter Mbah meets all completely. So you now pack that one aside. The next issue was the issue of forgery, which was the major crux of the petition against Dr. Peter Mbah around his NYSC certificate. Let us lay this foundation that, one, the tribunal in its wisdom said that from EC9, which was the form issued by INEC for you to indicate your qualification, write them down, Dr. Peter Mbah did not attach his NYSC certificate because, of course, it was not a condition precedent for him to run. If you go to INEC portal and look at the list of candidates, the final list of candidates, at number 297, you see that of Tijoke Edeoga. He front-loaded his first school leaving certificate, his WAEC, and his degree. If you go to number 294, that is the thought of Dr. Peter Mbah, he front-loaded his school leaving certificate, his WAEC, and his BL, which is his bachelor's degree in law. None of them front-loaded their NYSC. Now, it beats my imagination. Where did the petitioner get the NYSC certificate that they were claiming was faulty? Now, the only natural place they could have got it, because of course, if it was not in INEC, the only natural place they would have got it was from NYSC itself. And of course, you know, in Evidence Act, if you are bringing any document, a documentary evidence, it must come from the proper sector, from proper establishment. So the only place, they couldn't have gone under the bridge to tell a market woman selling akara to grab a research certificate of NYSC of Dr. Peter, but they would have gone to NYSC. And if they went to NYSC to get a certified true copy of that certificate, where was the original? That means NYSC had the original of that certificate number A808297, which only bears the name of Dr. Peter Mbah. The second aspect that you will look at is, if that certificate was said to be forged, where is the original? So I agree completely with the learned judges on the tribunal that for you to prove forgery of documents, there are two major ingredients as propounded, decided by the Supreme Court. One is either you have cloned an original certificate, in which case there is a cloning of the original, which now makes the other clone copy a fake one, or there is an adulteration or alteration of the content of the original, which makes it an issue of alteration. So if there is no cloning and there is no alteration, then where now lies the issue of forgery? And then the learned judges went ahead, because it was enough. It was enough for them to just dismiss the matter, because NYSC certificate was not enough, was not a requirement, precondition requirement for you to run as a governor. But they went to the kernel of the issue, such that justice will not only be seen to be done, but to be manifestly be seen to have been done. And they went to the kernel of the issue and now robustly looked at the issue of NYSC of Mr. Peter Mbah. So many things are germane, because one, Mr. Peter Mbah proved that he was deployed, mobilized by NYSC through a call-up and sent to Lagos for youth service in 2002. He proved that he started service and he was in camp. He proved that he was sent to NPA that rejected him and eventually redeployed to Ude and Associates, a law firm in Lagos, for his primary assignment. He proved that he, at a point after some years, after about 7 or 8 months, that he had to go back to write his bar final. He now wrote NYSC that he was going to write his bar final, and therefore he had to suspend his NYSC service. And it was responded by the NYSC, giving him authority and approval to go. It was also proved that he went and came back and wrote NYSC for a fresh redeployment. I mean, for him to continue. And NYSC redeployed him again to Ude and Associates. These are all in the public domain. I think the beauty of hearing in matters like this in court is that all the facts will come out from the various cupboards where they are hidden. These are all facts that are always in the public domain. He now came back, concluded his service with Ude and Associates, and it is very also instructive that throughout the 11 months plus 1 that he served in Ude and Associates, he got his clearance of service every month, and NYSC paid him every month for his NYSC allowance. And he got his final clearance and got his certificate. How can a man who has gone through all this now go and forge certificate? For what reason? Section 11 of the NYSC Act says that once a copper has met all these preconditions, it behoves on the NYSC to compulsorily issue him a certificate of use service. Right. So I see no reason why anybody would begin to say he forged a certificate when in effect he did not forge any certificate.
He mentioned, you're arguing for him in terms of whether he forged the certificate or not.
Which was the cause of the matter at the tribunal.
Yes, absolutely. But you also talk about the fact that the ruling was that NYSC was not even a requirement to being governor. And that's one of the things that Mr. Effiong had said yesterday.
Yes.
The fact that the core of the matter and the manner of the judgment was what he had faulted and where he felt they erred. That the statement here was the forgery of the certificate, and the fact that even though he didn't need that certificate to run, was there a case of forgery against him, which you've come to prove here in terms of that. But something else we picked out yesterday was the Evidence Act and the admittance of evidence, not just in this case in Enugu, but in other parts where we've seen petitions where evidences have been thrown out saying that they didn't come from the original source. Yes. And he tried to make a distinction between imitation and trying to source for the original document when it doesn't even exist in the first place. What do you have to say to that in terms of the requirement of the courts to get a document that doesn't even exist, and on that basis throw out a matter saying that because you couldn't obtain the original document in the case of imitation, it's not admissible?
I have said here that I am surprised that anybody, if Peter Mbah did not front load his NYSC certificate, who brought it out? And where did the person get it? Because there was something that was brought before the tribunal. And that was a certified true copy of his NYSC discharge certificate. So the petitioners must have gone to NYSC to bring it, only to come and say that it was forged. Understand the dynamics of the matter.
The NYSC DG on TV on this same platform said he didn't have a certificate, that they had concluded the matter. The video is out there.
The NYSC DG did not do due process. He did not do a diligent test.
So the
because
NYSC
I'm telling you that
because the NYSC said he had come to meet him on that issue. That's Mr. Mbah.
Yes.
And they said they had told him that Mr. Mbah, it's a no case.
Mr. Mbah took NYSC to court. The matter is pending, and in the process, the State Security Service, the DSS, or the SSS, if you like, had gone to do an investigation into what transpired between Mr. Mbah and NYSC. And all the facts have been laid bare. That one, NYSC issued, it was very obvious that NYSC issued Peter Mbah that certificate. Along the line, when Peter Mbah asked for postponement of his service, by the time he came back, his file was missing. It's all there in court. His file was missing. And NYSC had to create a temporary file. So if his file was missing within NYSC, what happened? And that is why that there was that discrepancy between the certificate he was supposed to have gotten, the one they call the 6 series, the one started with A6 something something, from the one that he eventually got, the stand was the A8 series, the one that A808297. NYSC would have gone
involved in this.
No, because
you have memorized another man's NYSC certificate number.
You know why it is important, Dr. Abati? The people of Enugu State are agitated. They want to know, have we elected a governor that is a fraudulent man? Or have we elected a man that will lead us? Okay, I'm here because of the people of Enugu State. I'm not here to talk in favor of anybody. Because the people are worried, and I want to tell the people that they elected a governor that will lead them, because their governor has committed no offense in the eye of the law, and that they should cooperate with the governor to move Enugu State forward.
We're trying to manage time. What is the status of that defamation suit? Because NYSC had approached the court to strike out the matter on the grounds that it lacks merit. And when last the matter came up in the court of, I think, Justice Nzeakor, right? So what is the status of that matter?
The matter is still alive. Because
it's alive?
Yes, it's alive. Because the prima facie evidence and the report of the SSS has shown that NYSC unnecessarily and unduly maligned Dr. Peter Mbah because of their failure to keep proper records and their failure to introspectively, internally check their system very well before running to town to begin to malign Dr. Peter Mbah. The matter is still alive, and I want to believe that it will, when you get to a logical conclusion, NYSC will have something to tell Nigerians in that regard.
All right, NYSC has a case to answer according to you, Mr. Nzeakor. Thank you very much for your time this morning.